In this video, I will explain 3 legal pitfalls when you expand your construction business to Latin America. I'm Santiago Cueto. I'm a board-certified international business law expert and best-selling author. And I've seen Miami construction firms make the same expensive mistakes when they take their business south of the border. These aren't small errors, they're deal killers. They can cost you millions and they can land you in legal trouble you never saw coming. Today, I'm walking you through the 3 biggest traps. More importantly, I'm showing you how to avoid them. Let's get into it. Latin America represents a massive opportunity for Miami construction companies. The region needs infrastructure, roads, bridges, commercial buildings, and residential projects. The demand is real. But here's what most firms don't realize. The legal landscape is completely different from what you're used to here in Florida. Different rules, different enforcement, different consequences. I had a client last year. They landed a $12 million commercial development project in Colombia. Everything looked perfect on paper. They were 6 months into construction when government officials shut down the entire operation. The reason? A permit issue they didn't even know existed. That project sat idle for 8 months. The financial bleeding nearly killed the company. And this wasn't incompetence. These were smart business people. They just didn't know what they didn't know. So let's talk about the 3 pitfalls that catch Miami firms off guard. The first pitfall is joint venture structure mistakes. Many Miami firms think they can replicate their US business model in Latin America. Well, they can't. Most Latin American countries require local partnerships for foreign construction companies. You need a local entity, you need local partners. But here's where it gets tricky. The joint venture agreements you're familiar with in the US don't translate directly. Each country has specific requirements about ownership percentages. They have rules about profit distribution. They have regulations about decision-making authority. I worked with a firm that formed a joint venture in Peru. They used a standard US agreement. They thought they were protected. 6 months later, their local partner legally forced them out of their own project. The agreement they signed actually gave the local partner majority control under Peruvian law. The US terms meant nothing there. The danger multiplies when you don't understand local corporate governance requirements. In Brazil, for example, certain corporate decisions require specific board compositions. In Mexico, foreign ownership restrictions vary by project type. In Argentina, currency control laws affect how you structure profit repatriation. You need local legal counsel who understands both US and local law. You need agreements drafted specifically for that jurisdiction. Generic templates will destroy you here. Now, if you're finding this valuable, do me a favor. Hit that like button right now and subscribe to this channel. I release new videos every week covering international business law issues that actually matter to your bottom line. Now let's talk about the second pitfall. The second pitfall is labor law violations. Latin American labor laws are nothing like US labor laws. Nothing. The protections for workers are significantly stronger. The penalties for violations are severe. In the US, employment is generally at will. You have flexibility with hiring and firing. You have clear rules about contracts. Latin America operates completely differently. Most countries in the region provide extensive job stability protections. Terminating an employee requires just cause. That just cause must be proven. The burden of proof sits entirely on the employer. If you can't prove cause, you're liable for substantial compensation. And here's a real example. A Miami firm operating in Chile terminated 3 workers during a project slowdown. They followed US protocols. They provided severance. They thought they were being generous. Those 3 workers sued. Under Chilean law, their terminations were illegal. The company ended up paying 15 months of salary per worker. They also paid legal fees. They paid penalties. The total cost exceeded $400,000. But it gets worse. Many Latin American countries have mandatory profit-sharing requirements with employees. In Mexico, workers are entitled to a percentage of company profits. In Peru, construction companies must distribute a percentage of net income to employees annually. If you don't structure this correctly, from day one, you face massive retroactive payments. Then there's Social Security and benefits. Every country has different requirements. Colombia requires specific healthcare contributions. Brazil has complex tax withholding rules. Argentina has mandatory bonus structures. Missing any of these creates liabilities that compounds monthly. You just can't export your Miami HR policies. You need local employment counsel before you hire your first worker. Now, the third pitfall is regulatory compliance failures. This is the one that blindsides Miami firms the most. The permitting process in Latin America is exponentially more complex than in Florida. It involves more agencies, it requires more documentation, it takes more time. In Florida, you're used to a relatively streamlined process. You apply, you wait, you get approved, you build. In Latin America, permits often require approvals from multiple government levels: federal, state, and municipal. Each level has its own requirements. Each level has its own timeline. Environmental permits alone can take 6 to 12 months. Labor permits require extensive documentation. Construction permits need architectural approvals that go beyond U.S. standards. Import permits for equipment and materials add yet another layer. I represented a firm that started construction in Ecuador with all their permits approved, or so they thought. Turns out one municipal office hadn't finalized their approval. That office had a 30-day window to object. They objected on day 29. The entire project stopped, and the delay cost over $2 million. Then there's the issue of ongoing compliance. Getting initial permits is just one step. You need to maintain compliance throughout the project. Regular inspections, regular filings, regular renewals. Miss one filing deadline and you're looking at fines, or worse, project suspension. Many countries also require local content minimums. You must use a certain percentage of local materials. You must employ a certain percentage of local workers. These aren't suggestions. They're legal requirements with teeth. The regulatory environment also changes. New administration brings new rules. What was legal last year might not be legal this year. You need someone monitoring these changes constantly. So those are 3 pitfalls: joint venture structure mistakes, labor law violations, regulatory compliance failures. So here's what you need to do before you expand into Latin America. Get local legal counsel in the specific country you're targeting. Not regional counsel, not someone who handles all of Latin America. Someone who practices in that exact jurisdiction. Structure your partnerships correctly from the beginning. Build compliance into your operations from day one. Budget for legal costs as necessary project expense. The opportunities in Latin America are real. Miami firms are perfectly positioned to capture them, but only if you do it right. If this video helped you understand these pitfalls, hit that like button. Subscribe to my channel for more content on international business law. I release videos every week covering issues that impact your expansion strategies. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.